So good morning, everyone, and welcome back to our weekly webinar series. Today's topic is an interesting one, something that has been talked about in the past many times: provident fund and gratuity, and the interface of these two acts and rather requirements under labor code or under the labor provisions with IBC. And let's go through the presentation, and let's understand what are the updated and latest judgments on this issue, and try and differentiate and rather declutter this space. Over to Anil sir, and I will share this in the meantime.
Thank you, Ankit. Thank you very much, and namaste to all the participants. Today, Ankit will lead the deliberations, and he will share the presentation that has been made by us. I am presently attending an industry association meeting. So I have just come out of that meeting to continue with our tradition of giving these webinars every Saturday, 11 a.m. So this is our 46th episode, and this subject, which is very, very important nowadays. There are a lot of controversies which we can see out of the provident fund and gratuity. And many resolution applicants are trying to understand their options. Many resolution professionals are trying to understand what are their obligations. And many lawyers are also trying to understand, and many bankers, many lenders are trying to understand whether they have any priority or whether they can avoid this liability of provident fund and gratuity because of the Supreme Court judgments. So what we are doing, what is the flow of this webinar today would be, first of all, there are conflicting judgments from NCLT, and you see the most important judgment would be the Sawan Godiwala, the liquidator of Lanco Infratech, and versus Apala. That is the judgment where it was said by Justice V.P. Singh that in case the funds are not available in provident fund or gratuity fund or the superannuation pension fund, then it is not the obligation of the liquidator or the RP to build funds into those funds, to bring funds into those funds. So there are two separate issues that we are handling, like what are the obligations under resolution plan and what are the obligations under liquidation. So then finally, we will conclude that what exactly would be the requirements and what should be the kind of way forward. So Ankit, you can start with the judgments which are in favor, or like as it comes, like so we are starting from the kind of date wise, which judgment came before, and then what happened, and then what happened. And now what is the latest judgment, which is the Jet Airways. So this is the way the webinar will be flowing today. Yes, over to you, Ankit.
Great. So let me share the screen and start. So a quick review of what we are looking at. We're looking at the concept of PF and gratuity, the relevant sections, and the judicial pronouncement. The first two we will try to do quickly, because I believe that many of us would already know PF gratuity. But yes, a quick preview of what is in store in these two acts and these two provisions, what is the background. We'll talk about that. PF, Provident Fund, we all know, anyone who has been an employee in his life knows that yes, there is a contribution which is the employee's contribution, there is an employer's contribution. Both contribute half of equal amounts. Employees can contribute more. And this contribution goes into what is called a Provident Fund. Provident Fund is maintained by the EPFO with the central government. There is also a provision for companies to go to the EPFO and say that we will maintain our own fund, and there the EPFO gives that mandate. And we have rather in our chartered accountancy firm done some audits of PF funds maintained by institutions privately, not with the government PF department. There the idea can be that somebody can say that, oh, we feel more secure to have a fund of our own. Somebody can say that we will make better returns out of the investments that we want to make, and so on. So there can be always that private fund. This money gets deposited in the PF account. It is managed by the government. As I said, it can also be a PF account or a PF fund, which is not managed by the government. Then the amount is tax-free. Of course, this has changed in the later years. In the recent finance bill, there have been proposals to tax a part of the PF contribution, which might be over a threshold limit, so that the richer can pay, so that the richer will have to pay more tax. The contribution towards the Employees Provident Fund is a statutory liability. It is governed by the EPF, Employees Provident Funds and Miscellaneous Provisions Act. And basically, the idea is then that Section 11(2) of the EPF provides that any amount due from an employer, whether in respect of employees' contribution or employers' contribution, shall be deemed to be the first charge on the assets and paid in priority to all debts, similar to how the Income Tax Department or IT Act or the GST Act or VAT Acts have talked about how can be a charge over the assets of an employer if the liability is not paid. Clause 29(3) of the EPF scheme states that the employer's contribution towards provident fund or for a workman or an employee covered under EPF scheme is calculated as the prescribed and applicable percentage of basic wages, dearness allowance, actually drawn during the whole month, whether paid or on daily, weekly, fortnightly, or monthly basis. So it is clear that PF becomes due or it becomes payable only on the actual payment of the salary. This is also something that is clear from clause 29(3) of the EPF scheme. Coming to gratuity. So gratuity comes from the word gratitude, and prior to 1972, it was paid in form
Here
of
I would like
gratitude to
to
the
add,
employees. Mhm.
Ankit, I would like to add certain things. So in this clause 29,
Mhm.
sub clause 3, we have seen that the provident fund is due only on the disbursement of salary and wages. Now we have seen in various cases the employee provident fund organization, they are issuing notices assuming that the salaries have been paid. Because you see, because the employer has not filed the returns, the company has gone into insolvency, there are non-compliances, and I have seen that the notices are coming for all these years when the returns are not filed, without even knowing whether the employees are still working or not, without even knowing whether the company is still continuing as a going concern or not. So what I'm trying to say here, that every notice from EPF4 is not a statutory liability. We all should mention in our RFRP, we should all mention into our RFRP that the resolution applicant will only be liable to pay the provident fund, which is finally crystallized under the Employee Provident Fund and Miscellaneous Provisions Act, not simply by way of a notice. So any notice which comes, that doesn't mean it is payable, because many notices are not exactly payable, because the notices are being made on estimates and guesstimates. Yes, Ankit, you can go ahead.
So, with respect to gratuity, 1972, it was paid as a form of gratitude to employees by the employer for being loyal to the company at the time of their retirement. And post 1972, it has become mandatory under the Gratuity Payment Act. Gratuity is paid to employees at the time of retirement by the employer, and it can be also paid earlier under certain conditions. Payment of gratuity is a statutory liability. Then Section 4 of the Act provides that gratuity is payable to an employee on termination of his employment after he has rendered continuous service for not less than 5 years, on his superannuation or retirement or resignation, or death or disablement due to accident or disease. And the first proviso of Section 4, of course, talks about certain exceptions where the completion of 5 years is not mandatory or not required for payment of gratuity in case the termination of the employment happens due to death of the employee or disablement in any way. So that is an exception, that gratuity will be payable for a shorter period also in case there is these are the two causes where the employment has ended because of that. So this is how the Gratuity Act talks about. So one, gratuity is payable after 5 years of employment in normal course. Gratuity provision is created in the balance sheet on accrual basis as per accounting standard 15 and as per the retirement benefits Ind AS. The idea is to capture the expense as you go along after assuming and after getting an actuarial certificate. This is how larger companies would provide for gratuity in their books of accounts. However, this liability is a provision. It becomes payable or it becomes due to be paid only after the employee has been or the employment has been terminated and these conditions are fulfilled. So, for example, in case an employee is with the company only for 3 years, and the company has provided for gratuity or provided for gratuity expense in its books of accounts for those 3 years, and he's terminated at the end of those 3 years, gratuity does not become payable and that provision needs to be reversed. So that's an example of how the gratuity works. PF, pension, and gratuity dues can be broadly categorized as. So this categorization is very important. So let us understand what all are these categorizations. So first categorization is that the workman and employee's contribution towards PF deducted from salary but not deposited by the employer with employees provident fund organization, exempted PF trust, NPS. So you're talking about employees contribution, which was deducted when the payment of salary was made to the employee, and that amount has not been deposited with the trust. The second is dues in respect of employer's contribution. The first one was employee's contribution, where the deduction was made from the salary and then the deposit was made. The second one is different. Now we're talking about the employer's contribution. The third one is dues in respect of employer's contribution for PF pension in respect of unpaid salaries. So the first two are with respect to paid salaries. The third is with respect to unpaid salaries. So say we are assuming, we say that there are certain salaries that have been not paid for the past 11 months. Now there can be PF dues which are also accruing along with the salary which is required to be paid. So one, the employee's basic salary or the salary will be required to be paid. That is a liability. Also, the employer's contribution will be added to that liability, assuming that the employee's contribution is part of his salary itself. So dues in respect of employer's contribution for gratuity fund in respect of both paid and unpaid salaries. So in many cases, in many companies, the gratuity is not kept as a liability in the books of accounts. Gratuity fund is created through LIC or other agencies, various other agencies, which say that we will keep the funds in custody, the funds that will be used by the company to pay its gratuity liability. And these are that is the contribution that we're talking about. So on an annual basis, the actuary would say that, okay, this is the fund balance you would need to meet your gratuity liability as on the balance sheet date. And the deficit is what the fund will ask the company to pay to the fund. So this is how the contribution to gratuity fund is computed in this case. So wherever the contribution or a gratuity fund is created, there is no requirement for a liability to be created in the books of accounts of the company, or the liability is created only to the extent to which the gratuity fund is in deficit to the gratuity liability. Then the balance outstanding in provident fund, pension fund, and gratuity fund at the time of commencement of liquidation. So here we are talking about PF, pension, and gratuity. These are terminal benefits, and they are basically employees' dues under statutory provisions. And these are basically these are incurred out of these funds that are created. For PF, the contributions are placed with EPFO or with the exempted PF trust. So as I said, there is a possibility that the liability is not in the company's books and the liability is already transferred, or rather the funds have already been transferred to the funds, the gratuity fund or the PF fund or so on. So these are the basic categorizations that we are looking at here. I have, I think the question is not relevant to the slide, so we'll take it up later. Yeah,
I
Answer can ask
will also add my experience over it. Now let us understand the obligations under resolution plan and obligations under liquidation. Now, when we talk about the employee's contribution, which is deducted from his salary, that is very clearly can be considered as the amount kept with the company on trust, which is supposed to be deposited in EPFO along with the contribution from the employer side. So that is something which is not part of the liquidation estate, and any amount which is balance outstanding in the provident fund, pension fund, and gratuity fund is maintained by the company. But then I understand that if any fund which is maintained by the company and which is managed by the company, that cannot somehow appear in the books of account of the company, but that has to be a separate fund. And I don't understand any situation where these funds are maintained in the books of the company. But yes, in case there are some funds where some balances are there, or those funds are not owned by the company as per section 36 of the IBC. Now, as far as this provident fund dues for the disbursed salaries are concerned, that is considered as the working dues. And as far as the in provident fund dues are concerned, which for the undisbursed salaries. So for the undisbursed salaries, this is something which can be part of the workman due. Now, in case of liquidation, it can be a separate treatment, and in the case of resolution, it can be a separate treatment. I think we can go ahead with some of the judicial pronouncements, and then we finally will conclude what presently all these judicial pronouncements are suggesting us to do. Yes, Ankit, please go ahead.
So I am proceeding forward, so I don't see any. Yeah, so this is the relevant provision in IBC. Important to understand section 53, that it has a non-obstant clause before it starts, saying that notwithstanding anything in the contrary to the contrary explained in any law enacted by the parliament or any state legislature for the time being in force. This talks about how workmen dues for immediately preceding 24 months and the employee dues for immediate preceding 12 months appear in priority over many other dues, and how the remaining parts of these amounts are then part of the other workmen dues which fall under clause F. And this is how basically the prioritization for workmen dues will be as per the section 53. And therefore it is understood that the provisions of IBC, because of the non-obstant clause, would override the EPF Act by virtue of section 53 as well as section 238. Some people can say that the rainbow paper judgment would disturb this, but then I think we understand that with the proposed amendments as well as other understandings, that that I would say would only be a temporary view. The long-term view would be to have section 53 as a distribution clause which overrides other acts. Of course, there might be an amendment based on the discussion paper released, that the all dues will be captured under one due, but there again workmen dues are kept separately. Then we need to understand the workmen due definition. So the definition, the IBC refers to Companies Act to understand workmen dues. The Companies Act talks about all wages or salaries, including salaries earned by way of commission or any compensation, and all accrued holidays, all amount due in respect of any compensation or liability for compensation, all sums due to any workman from the provident fund, pension fund, gratuity fund, or any other fund, and so on. So this is how the we talk about the various explanations, and how we can talk about all the parts of a workman due. Coming to the relevant part of liquidation estate, so section 36 of IBC says that liquidation estate does not include the sums due to any workman or employee from provident fund, the pension fund, or the gratuity fund. So our interpretation here is that these funds, provident fund, pension fund, or gratuity fund, would not be available or would not be forming part of the liquidation estate. So the creditors would not have access to these funds for the purpose of getting their money back during the liquidation process. So judicial pronouncement, this one is talking about relating to the PF. So this is called the term right to life that has been used in the judiciary. And this one is Precision Fasteners Limited versus EPFO, September 2018 NCLT Mumbai judgment, which talks about the right of all creditors over the assets of the company is a property right. whereas workmen dues, more specifically PF dues of workmen, are interwoven with right to life. So this is how this judgment talks about or differentiates the rights of workmen against the company. The workmen all through their life save some portion of hard earnings, and this is how it talks about how this is hard earned money of the workers. The amount due to workmen employees from PF pension or gratuity will not be included within the purview of liquidation asset, and same is to be excluded from the liquidation estate so as to enable the workmen employees to realize their savings. Liquidators shall pay off the said dues before comprising the liquidation estate. So observation of the Honorable Tribunal was that pursuant to Section 238 of the IBC, it will override anything inconsistent with the code, including EPF Act, and that the workmen dues as payable under EPF Act will not be considered in priority of payment under Section 53 of the Act. So this is how this judgment talked about. This is the second judgment, which is basically Karpagam Spinners Private Limited. Again, this was a so this is that judgment. Let me come to the next one. Alchemist versus Moser Beer India. This is an NCLT judgment. The tribunal here upheld the judgment in case of Precision Fasteners. Further held that the liquidator cannot avoid the liability to pay gratuity dues to the employees on premise that no separate fund was created by the CD. So the liquidator has to ensure that the funds are created and distributed to workmen outside Section 53 waterfall. So the liquidator must provide these funds even if there was no diversion of such funds by the CD. So at the NCLAT level, this order was confirmed. So this is how this judgment then came in, which extended the liability to the funds of the CD. This is a case where the funds were not available, there was no fund available, and the liability or the gratuity dues were not taken into account, or rather not it was said that these will not form part of Section 53 waterfall, and these need to be taken care of differently. Mr. Savan Gudiwala versus the Apala Siva Kumar. This is an NCLAT judgment, February 2020. Here the facts were so on. So the facts were that this appeal emanates from the order passed by the AA, whereby the AA directed the liquidator to pay gratuity to employees, and the liquidator could not avoid the liability to pay gratuity to the employees on the ground that the corporate debtor did not have separate funds for payment of gratuity. AA further directed the liquidator to provide sufficient provision for payment of gratuity according to eligibility of the employees. So by the impact order, AA rejected the contention of the liquidator that the payment of gratuity cannot be treated as part of liquidation estate. The appellant contended that as per requirement of Payment of Gratuity Act and Section 36(4)(a)(3) of the Code, the charge will remain in force against the assets of the corporate debtor until the gratuity dues have been paid off before making any payment to any entity falling under waterfall mechanism devised under Section 53 of the Code. So they kind of use the charge that was part of the PF Code, PF Act, to kind of give priority to the payment, this due. Whether a liquidator can be directed to make payment of gratuity to employees of the company in case no fund is created by a company in violation of statutory provisions of Payment of Gratuity Act 1972. So decision that in case where no fund is created by a company in violation of statutory provisions of Section 4 of the Payment of Gratuity Act, then in that situation also the liquidator cannot be directed to make the payment of gratuity to the employees, because the liquidator has no domain to deal with the properties of the corporate debtor which are part of the liquidation estate. So it is further held that in the above case, Section 53(1)(b)(1) of the Code regarding distribution of assets relating to workmen's dues are confined to a period of 24 months preceding the liquidation commencement date, and this question was already been decided by the gratuity fund does not form part of the liquidation estate. So, however, the AA has given direction to the liquidator that the liquidator cannot avoid the liability to pay gratuity to the employees on the ground that the corporate debtor did not maintain separate funds, even if there was no fund maintained by the liquidator. So, the NCLAT judgment reversed the NCLT judgment. So, this is how this judgment was concluded. The Honorable Supreme Court then decided on, or rather deliberated, the matter of the Moser Beer case, and this was a 7th February 2023 judgment. pretty recent. And here we talk about how the the facts of the case, that NCLT initiated this case against Mozambique. 29/2018, the Honorable Tribunal ordered for liquidation, and accordingly, the workmen of Mozambique stood discharged under Section 33(7) of the IBC. The liquidator, by an email, categorically denied the payment of the gratuity fund, the PF and the pension fund preferentially, and included the same for payments under the waterfall mechanism under Section 53 of the IBC. And in 2019, the Mozambique Karamchari Union filed an application with a prayer with the directions to be issued to the liquidator to exclude the amount due to them towards PF pension fund and gratuity trust fund from the waterfall mechanism, and therefore the appeal was filed regarding the same. So the question here is that whether PF pension fund and gratuity fund can come within the meaning of assets of the corporate debtor for distribution under Section 53 of the code. So the decision was that in two civil appeals involving issues with respect to payment of gratuity and provident fund prior to disbursement under Section 53 of the code. In liquidation process, the division bench of B.R. Gawai and Mr. Vikram Nath quashed and set aside the NCLAT order passed in Sawan Godiawala and restored the order passed by NCLT that the provident dues, provident fund dues, pension fund, and gratuity fund dues are not treated as part of the liquidation estate and would not therefore be recovered by Section 53 of the IBC, which provides for waterfall mechanism. Then in Appala Sivakumar versus Sawan Godiawala, the court said that the order impugning the present appeal passed by NCLAT, that in case where no fund is created by a company in violation of the statutory provisions of Section 4 of Payment of Gratuity Act, in that situation also, the liquidator cannot be directed to make payment of gratuity to the employees because the liquidator has no domain to deal with the properties of the corporate debtor, which are not part of the liquidation estate, is in ignorance of its earlier order dated 19th August 2019, which was affirmed by Civil Appeal 258 of 2020. Thus, the court quashed and set aside the NCLAT order and restored order passed by the NCLT. Thus, PF dues, pension dues, and gratuity dues are not treated as part of the liquidation estate and would not therefore be recovered by Section 53 of the IBC code, which provides for waterfall mechanism. So, difference between the two cases. Let us try and understand what happened in the Lanco Infratech case, what happened in the Mozambique case. So, in Lanco Infratech case, the NCLT directed that the liquidator should pay gratuity dues to the employees even when the CD has not created separate gratuity funds, and held that gratuity fund do not form part of the liquidation estate even when no specific funds were created by the CD. In the Mozambique case, NCLT by order held that PF dues, pension fund dues, gratuity fund dues do not form part of liquidation estate and cannot be part of Section 53 dues. In the Lanco Infratech case, the NCLAT, while hearing the appeal, held that where there are no specific funds created for gratuity, the liquidator should not have been directed to make the payment of gratuity as per the worker's entitlement. In Mozambique case, NCLAT upheld the stand of the NCLT. In Lanco Infratech case, NCLAT in its judgment specifically held that it is not the liability of the liquidator if no separate funds were created by the CD, and thus there is a contradiction from the Mozambique judgment. NCLAT, in Mozambique, NCLAT in this judgment held that the liquidator cannot avoid the liability to pay gratuity dues to the employees on the premise that no separate fund was created by the CD. So to summarize this, maybe I will request...
Ankit, maybe like I would now chip in a little. So there are two cases, both are in liquidation. Lanco Infratech as well as Mozambique, both are in liquidation. And in both cases, right from the NCLT, it has been the opinion of the bench that the Provident Fund, Pension Fund, and the gratuity fund are to be paid to the workman in priority and will not be considered as assets for distribution under Section 53. So that means the workman dues, which actually falls in pari passu along with the secured creditors, that particular clause is not applicable on the Provident Fund part of it and gratuity part of it. And this the criteria of 12 months and 24 months, which is mentioned in Section 53, is also not applicable to the provident fund part of it and the gratuity part of it. And in Lancora, in fact, the NCL 80, the appellate tribunal, held differently. However, in Motherbeer, NPAD also held, like this in the case of Motherbeer, this judgment was given by Justice Mukhopadhyay. And in the case of Lenco Infratech, this judgment was given by Justice VP Singh. So both differ from each other. And however, the Supreme Court finally held that in liquidation, the provident fund dues and the gratuity dues would not be considered as distribution of assets under Section 53, and the liquidator would have to provide for these from the assets of the company, and whatever remains, that will go to Section 53 distribution. So this is something which is very, very clear now, but the liquidators must understand that every demand is not a valid demand. Every provident fund demand is not a valid provident fund demand. It is the duty of the liquidator to understand whether the gratuity claims are correct, whether the provident fund department is asking for a correct claim. So when we say the first part of the category of the provident fund dues are the amount, the provident fund dues on the salary which is disbursed. So that is something which is has to be paid, because that is the amount deducted from the salary and it has to be paid. Secondly, the provident fund dues on the disbursement on the disbursed salaries, that is also payable. However, when we talk about the third part, which is the provident fund dues on the salary which is not disbursed. Now, whatever finally gets disbursed under Section 53, the provident fund is payable only on that amount. Now, in case in Section 53, the workmen are getting 12 months work wages or 24 months wages, and on those wages, whatever pari passu along with the secured financial creditor, in case they are getting say 30% of their total wages, so the provident fund would be payable on this 30% and not on the 100%, because the provident fund dues becomes due only on disbursement and not on accrual. So similarly, the gratuity is, of course, it has to be payable. Even my personal opinion is that anyone who is working for 50 years in a company and once the company goes into insolvency and the liquidation, that gratuity cannot be eaten away. Nobody can eat away that gratuity. That's something which is a social pillar of our organization, where the economic stability of a human is involved. Gratuity is a kind of contribution to the economic stability of a human. So therefore, gratuity has to be provided for, gratuity has to be paid, even in the liquidation or in the resolution plan. So I think we have concluded as far as the liquidation part is concerned. And now I will say, Ankit, to go ahead. And there are other judgments also, which we will take up.
So let's understand this one. This is Sikandar Singh Jamawal versus Vinay Talwar and others. Here, the background is that in this case, an appeal was filed by an ex-employee of respondent number 3, corporate debtor, challenging the order dated 2/4/2019, passed by the AA, approving the resolution plan. Grievance of the appellant was that they have not made the full payment of the provident fund due to the corporate debtor, and other ground due by the corporate debtor, and other grounds of challenge were also raised. So here the observation was that the tribunal considered the appeal, and based on the provisions of Section 53, and a reliance was placed on the judgment of Tourism Finance Corporation of India versus Rainbow Papers, and issued following direction that the respondent number 2, successful resolution applicant, should release full provident fund dues in terms of provisions of the Employee Provident Fund and Miscellaneous Provident Fund Act immediately by releasing the balance amount. So the impugned order approving the resolution plan stands modified to the extent above. This is how they passed this order and basically said that the resolution plan would have this additional requirement to be fulfilled. So against the above judgment of this tribunal, civil appeal was filed before Honorable Supreme Court, which has been dismissed on in September 2022. The Supreme Court has also accepted the same idea that if the provident fund dues have they should have been paid in full based on this judgment. And Sunil Kumar Jain and others.
This can also be seen, Ankit, as the resolution plan is getting modified without the consent of the resolution applicant.
Yeah.
Now, the resolution applicant can further say that it is not viable for him, that he also pays the provident fund, superannuation fund, and gratuity fund, and also pay to the creditors whatever he has committed. So, modification of resolution plan by the Supreme Court or by NCLAT is being done. In this case, it has been done, and in the case of Jet Airways also, it has been done. So what I'm trying to now say, once the Supreme Court says, yes, we can modify the resolution plan, and then it may trigger into various such issues which the NCLT might even start saying that this is some kind of little bit of modification which is required, and that modification we are making, and the resolution applicant will accept it or will have to accept it. That kind of scenario may start now, because these are the two judgments where the resolution plan has been modified, additional amount has been directed, the RA has been directed to shell out different amount or higher amount as compared to what he originally said. So these two judgments will actually somehow, I feel, that will give power to NCLT to modify the resolution plan, which is somehow not really not very acceptable. So this will further deteriorate the market and will discourage the resolution applicants to come in the resolution process. Rather, they will prefer to go into the liquidation process.
Yeah.
Yes, Ankit, continue.
This one is Sunil Kumar Jain and others versus Sundaresh Bhatt. And this is a Supreme Court of India judgment dated 19th April 2022. Here we're talking about how NCLAT dismissed an appeal preferred by the workmen employees of ABG Shipyard against the NCLT's order denying relief to the workmen employees with regard to their claim relating to salary, including PF and gratuity for the period involving CIRP and the prior period thereto. Agreed by the said order, workmen employees preferred appeal against Honorable Supreme Court before the Supreme Court. The issue was that with respect to wages, salaries of the workmen during the CIRP period and the amount due and payable to the respective workmen employees towards pension fund, gratuity fund, and provident fund. So the appellants contended that the salary, wages, and the dues payable to them during CIRP period will be qualified as CIRP cost and are liable to be disbursed even prior to the amount distributed under Section 53 of the IBC. It was further submitted that the provident fund, gratuity, and pension fund amounts remain outside the liquidation under Section 36(4) of the IBC. On the other hand, the respondent contended that the wages and salaries claimed by the appellants who have done no work during CIRP period and have not assisted the resolution professional liquidator during the CIRP would not fall within the parameters of CIRP costs within the definition of Section 513C of the IBC. Decision of the Honorable Supreme Court was that they said that while considering the claims of the concerned workmen employees towards wages, salaries payable during CIRP, first of all, it has to be established and proved that during CIRP, the corporate debtor was a going concern and that the concerned workmen employees actually worked while corporate debtor was a going concern. Therefore, two-step formula have been evolved, and exclusion has also been evolved wherein the wages and salaries of all workmen employees of the corporate debtor during CIRP who actually have not worked or performed their duties when the corporate debtor was a going concern shall not be included automatically in the CIRP cost. Further, the wages and salaries which are included in the CIRP cost shall have the first priority in terms of 53(1)(a) of the IBC, and other wages salaries which are not included in CIRP cost shall have to be governed by 53(1)(b) and 53(1)(c). So on the issue of provident,
I can briefly deliberate on this particular judgment, Sunil Kumar Jain versus Sundaresh Bhatt, the liquidator of ABG Shipyard. It was primarily on the salaries and wages payable or not during CIRP. So it was very clearly held that one, the salaries and wages would be payable under the following circumstances. One, that the company is kept as a going concern. Number two, that employee and the workman is working for the company, and that too, assisting the resolution professional in the operation. Number three, the committee of creditor has approved the salary and wages of those employees. So if all these three conditions are fulfilled, then those particular people will get their salary as a CIRP cost, and others will not. As far as the up to CIRP date is concerned, they will file their claim. They will file their claim for the provident fund. They will file their claim for the gratuity. They will file their claim for the superannuation fund. So those will be treated separately. However, during CIRP, whether it is payable or not, that will depend upon whether they are still working, whether the company is continuing, whether the COC has approved or not. So these are the three conditions. As far as this part is concerned, regarding the provident fund, regarding the superannuation fund and gratuity fund, this particular judgment only discussed in one paragraph and simply said that yes, any money lying in these funds would not be considered as an asset of the liquidation estate. So I think this judgment was not focused on the priority of the provident fund and the gratuity fund.
So yes, I think that's the right conclusion for this judgment. Also, further, we are talking about here that the Supreme Court, of course, has talked about how the funds will continue to be outside the liquidation estate. Then coming to B. Parameshwara Udpa, RP of Osun Ray Royal Limited versus Assistant PF Commissioner. This is NCLAT judgment from Chennai 23/9/22. Here the facts were that the CIRP was initiated in 2020. The IRP came across orders of attachment issued by EPFO. SPI responded to the EPFO stating that in terms of Section 18F of IBC, the RP has ownership over all assets. The issues were whether the RP is duty bound to make adequate provisions for PF even though the corporate debtor did not have separate PF account, and whether the AAA can direct RP to make provisions for PF without receiving claims for the same by concerned authority. So the decision of the Honorable Court, let us understand the major observations here. It was observed that the amount deducted by PF purely belongs to an employee and is not an asset of the corporate debtor. The PF amount cannot be touched by IRP, RP or liquidator. The PF is to be an establishment fund kept separately by the company, and then only this provision will be applicable. And if even wrongly and in violation of the laws of the land, the company fails to establish such provident fund, then the interim judicial professional RP liquidator is not expected to provide for same except under Section 53 of the code. So this judgment then talked about how if the fund is not available, then the fund is not required to be created by the RP or the liquidator. Jet Aircraft Maintenance Engineers Welfare Association versus Ashish.
This is something which is slightly different and Chennai. Primarily, this particular judgment was saying that the EPFO has got no right to attach the assets of the company. They have to release the assets in favor of the RP, and they have to file their claim, and the RP will consider, or the resolution applicant will consider their claim, or the liquidator will consider their claim. However, they cannot continue with their attachment. So I think we should only consider this part of the judgment, and the other part of this judgment. That it will be considered in Section 53. That is not something which the Supreme Court has finally said yes. The Supreme Court has said in two liquidation cases that Section 53 would not be applicable to these three funds. In resolution plans, the Supreme Court has said that the RA will have to pay for the provident fund and the gratuity fund. In fact, there are two judgments also in Supreme Court where the RA has to pay additional funds for PF and gratuity and superannuation. And one we have already discussed, and the one is the last judgment, which is the Jet Airways, which is now coming forward. Yes, Ankit.
In Jet Airways, this matter of where the association had a case against Ashish Chacharia, and this was NCLAT judgment, October 22. Here, the issue was whether the workmen and employees are entitled to receive the payment of provident fund, gratuity, and other entitlement benefits in full since they are not part of the liquidation estate, whether the workmen and employees are entitled to receive their dues from the corporate debtor as per provisions of the code, the minimum liquidation value envisaged under 32B by referring to waterfall mechanism. So the contention here was that, of course, the the council laid that the appellant or the workman employees are entitled to the PF gratuity and other workman benefits, other retirement benefits, and the submissions were supported by section 36(4) of the code. Then, of course, thus the sums due to any workman from the above funds.
All these contentions are similar. I
Yeah.
think we can move on
So
to the,
let's
because
try
of the
to the
time.
let's
What
try
is the
let's
time left?
yeah
That's
let's
also
try
key.
and understand the observations here. The workmen were entitled to issuing appropriate direction to successful resolution applicant to make payment of the workmen of the PF and gratuity dues up to the date of insolvency commencement date, less the amount already received under the resolution plan, and the gratuity and the corporate debtor having not deposited the statutory dues with the EPFO, the said statutory liability has to be discharged by the SRA. The observation further said that when we look into the explanation of section 18, the assets comprising of provident funds, gratuity funds, or a pension fund and belonging to be maintained by corporate debtor are assets on which employees and workmen have right, although assets are in possession and control of the corporate debtor. So the above mentioned assets thus are not to be taken control by the IRP after initiation of CIRP. So hence the sent funds were maintained by the have to be utilized for the payment of provident fund, pension, and gratuity fund, and thus assets cannot be included in the information memorandum as assets of the CD. So the workmen and employees are entitled for full payment of provident fund and gratuity till the date of commencement of insolvency, which amount is to be paid by SRA consequent to approval of the resolution plan in addition to the 24-month workman dues. So this is how the observations were closed here. CG Vijayalakshmi versus Sri Kumar Rajan, NCLAT judgment, Chennai, 8th February 2023. So, quick facts, it's a PSU, Hindustan Newsprint Limited, which is a wholly owned subsidiary of Hindustan Paper Corporation Limited. And basically, the corporate debtor has admitted to CIRP in 2019. And there was an basically Kerala Industrial Infrastructure Development Corporation submitted a plan and it was approved by the COC. The resolution plan proposed that the secured financial creditor would be paid 45% of the total principal amount. The PF dues and gratuity claims of all employees were also paid at 35% of the admitted dues, at par with secured financial creditors and workmen. Thereafter, the adjudicating authority, by its order dated 21, approved the resolution plan of the SRA, and the employees and the workmen of the corporate debtor filed appeals before NCLAT challenging the order of the resolution plan. The question was whether the dues have to be paid in full. Same question. Decision of the NCLAT, and basically they said that workmen and employees are entitled for payment of full amount of provident fund and gratuity till the CIRP commencement date. So this is how this expenditure or this due was also said to be in superposition of the other dues. So such amount is payable by SRA after the approval of the resolution plan in accordance, in addition to the 24 months workman dues, and the bench directed the SRA to make payment of unpaid provident fund, gratuity fund, and pending dues to the workmen till the date of CIRP after deducting the amount already paid. So same decision again. So to summarize, I believe that yes, I think there are so many judgments now that we have gone through where yes, we understand that the Supreme Court and the tribunals have repeatedly said that the PF dues have to be paid in full, and that's the judgment here. But then, as we said that there might be difficult scenarios, as this case where we talked about how the successful resolution applicant has been asked to pay the dues in full. So it will make the plan unviable and maybe difficult for implementation if others are not getting anything and the PF and the employee dues will be paid in full. So,
Ankit, my understanding is like this is not going to be a very large amount. Why I'm saying so? Because see, the provident fund dues are only payable in case the salary is disbursed. So that will be small amount. However, the gratuity can be very high in some cases. So the gratuity has to be paid. That's what is my understanding, and that's what is my feeling that the insolvency law has got it. I don't think that can be the intent of the legislature, that even the gratuity can be eaten away by the creditors. That cannot be the intent of the legislature. So the gratuity is something which is the life-saving of a workman or an employee working for 30 years for a company. So that has to be provided for in the resolution plan. That has to be paid by the liquidator in liquidation process. And there is no dispute about that gratuity part. However, for provident fund, I have different opinion. I am saying that the provident fund is payable only against the I think you can stop sharing the screen if you're not required, because we can take up some questions.
And conclude afterwards on what the various dues can be categorized
Yes,
as. So
yes,
that's why
yes.
I just shared this.
So this is
So,
something which is important. This is something which is important. So now what we are trying to say is that the provident fund for which the demand has come from EPFO, that has to be dealt with by the RPs very, very strongly. It should not be admitted just on the face of it. It should be admitted only to the extent the salaries have been dispersed. For the other part of the provident fund demand, the EPFO should be should 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 be put on a test whether these are the real demand or not. Now, my second opinion is that in case of the interest and in case of the damages, delayed payment damages, that is the amount which doesn't go to workman. That amount goes to the EPFO, and that should be segregated. That should be considered as these statutory liabilities under Section 53, and should be considered as an operational creditor. The provident fund dues should be restricted to the dues which goes into the account of the employee, not in the account of the EPFO, like the interest for delayed payment, damages for the delayed payment, because they have Section 7 capital A. Any amount which is payable under Section 7 capital A should not be considered the provident fund dues. So these kind of categorization has to be made by the RP. The incorrect demand notices should be kind of appealed against, or should be challenged. That's what my understanding. So the resolution professionals, they will consider the PF notices very carefully. They will admit only the part which is likely to be admitted. Let the Provident Fund Department goes to the NCLT. Let it be adjudicated. What part will go to which category, and what part will go to which category. Let that be decided from now onwards. Because once we have now seen that there are now 3 judgments from Supreme Court that they have said that the Provident Fund and the gratuity has to be paid. So I don't think there is going to be any change in this, because even the government doesn't want that the gratuity should be eaten away by the insolvency process. So I think we can take up some questions depending on the time available. What is the time available?
we have about 5 minutes, so there are many questions. So let me try and take them up one by one. So let me start with the recent question that has come in. That this is from Mr. Maladi. Even after the payment by the liquidator, the EPFO is not distributing the amounts to the employees. Moreover, the damages as per Jet Airways judgment should be paid in priority. What are your comments on that? So I think whether they are not paying, I think that has to be taken up with the EPFO. I don't think that's an EPF, that's a IBC issue, as long as the PF dues payable to the EPFO have been paid. The EPFO has to distribute them. If the EPFO is having difficulty in distributing them to the employees and they need certain information, then they need to devise a mechanism, or rather the insolvency professional can provide the information available with him. Don't see any other way there. Because yes, that's a problem that say the EPFO raises a demand, but then which employees does EPFO allocate that amount to, without understanding the names, without understanding what amounts have been paid to individual people? So this can be an issue.
Yes.
Then Mr. Daita says that, can RP reject the penalty and interest demand of EPFO? And I don't think the interest and PF can be rejected. That demand will also have to be admitted. The penalty will also form part of the dues, in my opinion.
No, Ankit,
Your
so there are
opinion?
2 parts of it. One is the claim admittance by the RP. Now, the claim admittance by the RP is some part where it is mentioned in the definition in IBC that even if disputed claim, the RP has to accept it. No, that doesn't mean that it is payable by the resolution applicant. The resolution applicant can fight it out and can find out what are the actual crystallized demand from the EPFO. And finally, that would be payable. So this is what is my understanding, that admittance is possible. Admittance has to be done. RP doesn't have any power to adjudicate all these claims. However, the adjudication, the payment will be subject to the adjudication by the relevant court or relevant appellate authority under EPFO.
Okay. Then you have a question that.
But while admitting, the RP should categorize it. RP should admit the interest and damages under the statutory liabilities as operational creditor, and RP should admit the provident fund, which is the amount which goes to the account of the employees. That should be admitted as the provident fund, which will be payable over and above the section 53 liquidation assets.
But then, like, if we follow this judgment and say the PF dues will be in priority to the waterfall mechanism, aren't we kind of making IBC very, very inferior to SARFAESI? Because then why will somebody with a secured asset come to IBC at all? No bank will take any company to IBC. Because in case you're saying...
SARFAESI is basically selling the assets. SARFAESI is not talking about the companies as going concern.
So we are talking... So if we talk about a company which is not a going concern, there when the company comes into insolvency and there are certain secured assets, those secured assets will have to be sold to discharge the PF liability as per these provisions.
No, even SARFAESI law says, that the workman dues will have to be paid as pari passu along with the secured financial creditors.
But pari passu is different from complete payment.
Yes, I think you're right. I think the SARFAESI Act has not seen this kind of litigation, but insolvency has seen this kind of litigation. And now, since this has come out, I think in SARFAESI also, there may be some litigation for, but then there is no such clause in SARFAESI law which says the provident fund, pension fund, and the gratuity fund will not be part of the assets to be considered in the liquidation estate. That clause is not there.
Because ultimately, with respect to all the funds that we're talking about, all the gratuities that we're talking about, these are essentially benefits for the employees and the workmen. And in case these liabilities were unpaid, then as per current section 53, it would form part of the amounts payable to the employees or the workmen, even if it is indirectly through the EPFO. But then, yes, I think there are other judgments now also which talk about statutory liability. So then we have a question from Sanjay Devani ji. Treatment of EPF dues only consists of damages and penalty under liquidation process, penalty and damages for not filing EPF returns on time, penalty dues already paid. Not understood.
I think we have answered this. We have answered this
we have talked about this.
We've talked about penalty. We've talked about damages. We talked about interest, and we talked about the provident fund dues as such, which goes to the workman account. So we kind of categorized it separately, and accordingly, the RP has to admit the claim. In case the RP will admit claim in this manner, then let the EPFO goes for an appeal. Let it be adjudicated.
Yes. So Sanjeev ji is saying that in case notices are received from CIRP before CIRP from the EPF commissioner and the proceeding continues after CIRP, although though the claim is not submitted by EPF commissioner, then whether we should consider the claim. So I think there is a duty for the insolvency professional now to seek the claim from the people where the outstanding is visible from certain documents or books of accounts available with the company. And I don't see any reason why the EPFO will not file a claim in case they come to know that the CIRP has started. In many of our cases, the EPFO has filed the claim once we have approached them that yes, the CIRP has started, and you're please requested to file your claim.
In my understanding, the EPFO is not filing claim in many cases. They are saying that we have a priority. We are not supposed to file our claim. However, the RP has got no power to admit a claim without filing. If somebody doesn't file the claim, RP has no power to admit. However, all this information which is available with the RP, that should be mentioned in the IM, information memorandum, so that the resolution applicant should consider that.
Yeah. So I think to conclude, as per Supreme Court orders, the liquidator is required to distribute the EPFO in priority, even where there are no separate fund is maintained by the CD. So I think this is the final confirmation that we can give and then wind up.
Yes, we can wind up, but I think with the gratuity, 100% yes. With the APF, we are saying categorize it and only admit this, only give top priority to the amount which goes into the workman account. All other kind of amount, which is penalty, damages, and interest, should be admitted as statutory liabilities and should be considered under Section 53. Let the EPFO goes to the adjudicating authority to get it adjudicated. The provident fund does not mean the penalty. It does not mean the damages. It also does not mean the interest.
Okay, I think that's a fair conclusion. So I think there are many other questions, but I think time is a limitation. So we will have to wind up, and maybe then we can continue with another topic next Saturday.
Thank you very much. Thank you. So we are continuing today. Today I was participating in an industrial association event. So I just took 1 hour out, and in fact the preparation was done yesterday when I was coming back from Mumbai. In the flight, Ankit also did this preparation. So we are really happy that you all are associated with us. You are all connected with us. In this next week, we are coming with the subject of information utility, how this information utility is functioning, how the transactions are supposed to be uploaded, how the information utility is now getting important, and how the transaction will be verified by the IU, and all these related regulations and the related piece of law. Thank you very much, all the participants. Thank you, Ankit.
Thank you. Thank you, everyone. All right. Bye.